warm welcome and thank you for joining me today for Wills and Trusts Navigating Estate Planning Basics. Hi, my name is Lynn St. and I'm an estate planning and elder law attorney with ELG Estate Planning. We serve clients in Spokane, Tri-Cities, and the Seattle area. Again, thank you for joining me today. Wills and Trusts. These are estate planning basics, but sometimes they're a little bit difficult to understand, so we are going to be talking about those today. We are not going to be covering my favorite estate planning documents, which are your living documents, meaning your durable powers of attorney for finances, for healthcare, and your advance directive, also called a healthcare directive and a living will. And I am not tongue-in-cheek when I say those are my favorite estate planning documents. And the reason for that is that when somebody is alive and if they need them, they need them. Without those documents, if you were to lose capacity, you will become a ward of the state, which is not a great outcome by any means. But we are not covering that today. I always however, want to give a shout out to the living documents because they are so important. But today we're going to be talking about what are called estate planning dispositive documents. The reason that they're called dispositive is that they dispose of your assets when you are gone. So everybody knows what a will is. It's that legal document that you sign, and on your death, it says where your stuff goes and who gets it. A revocable living trust says pretty much the same thing, but it's a little bit different because it is in effect during your lifetime as well as upon your passing. And upon your passing, there's a successor trustee who carries out what your wishes are. So we're going to be talking about why you might want to choose one over the other. Let's start with a will. A will directs your assets where they go upon your death. A will can create a trust for your beneficiaries. Probate is required. There is no ongoing maintenance required of a will. That's not to say that you're not going to update your will as life circumstances change, but if everything were to remain the same, the will that you signed 20 years ago is the only will that you need. With a will, there is no requirement that you retitle your assets in any respect. So, for example, you don't take your house and put it in the name of your will, unlike what you would do with a revocable living trust. In short, it is far simpler to have a will as your estate planning tool rather than having a revocable living trust. So it is simpler, but is it the correct thing for you? Let's talk about revocable living trusts. A revocable living trust is a legal entity. You sign a document during your lifetime where you create this thing called a revocable living trust. It is revocable, which makes it attractive because if you change your mind, you are not stuck with it. It does require maintenance, unlike a will. We're going to talk about that in some detail. Now, I want to distinguish between a revocable living trust and an irrevocable trust. Irrevocable means you can't change it. It is, once you have signed it, it is not changeable. That's why it's called an irrevocable trust. It is something that you can create during your lifetime, an irrevocable trust, or your will and your revocable living trust also can create irrevocable trusts upon your death. Why irrevocable trusts can be attractive despite the fact that you can't change them is that if you put assets into an irrevocable trust, they are considered outside of your estate And if they are outside of your estate, they are not going to be taxed as being within your estate on your death. So it is a great way to reduce any estate taxes by making this gift to the trust. It is a great way to protect assets against creditors that may come up. And it's also a way not only to protect against taxes, but at the same time, you can also create irrevocable trusts to qualify for Medicaid long-term care benefits. So irrevocable trust can be extraordinarily powerful in the right situation. Because it is irrevocable, you are definitely going to want to work with an estate planning attorney, especially if you're talking about reducing taxes. And if it is for Medicaid long-term care qualification, you're going to want to work with an elder law attorney who understands Medicaid's rules. So irrevocable trusts are really not where we're focusing our time today, but I want you to be aware that they exist and they can be a very powerful planning tool. Okay, let's talk about who is involved with all of this estate planning. So let's use some names. When you're talking about a will, the person who signs the will is called either the testator, the testatrix, that's male versus feminine. And of course, we're lawyers, so we throw in all the Latin, last will and testament. But the person who signs it, we'll call them the testator. The person who dies, well, that's the person who signed it, and they're called the decedent. The personal representative, or the executor, or the executrix. Now, that is the person that you've designated in your will to carry out the terms of the will. This is the person that you've nominated and that the court will appoint to carry out the will. Beneficiaries. Those are the people or the entities who receive under your will. I want to make a little bit of a side note that with a will, there can be beneficiaries of other assets that don't pass underneath the will. Think of your 401k or your life insurance policy. Those pass by way of a beneficiary designation. Or you could even have a bank account that you hold joint tenants with right of survivorship with somebody. On your death, that goes to the joint owner. You can have a bank account that you say pay on death to somebody. So that goes to whomever you've designated. So all of those are non-probate assets, meaning they don't pass under the will. Yes, you heard me say probate. We are going to be talking about a will requires probate. Heirs at law, you may have heard that term. Who are the heirs at law? Those are defined by statute to be the people who would have inherited from you in the absence of a will or a trust or other mechanism for them to inherit. So, for example, maybe you're single and you have 2 kids and you want everything to go to your favorite charity. If you don't have a will or a trust that says that, then your 2 kids are your heirs at law, and they are the ones who are going to inherit from you. So if you don't want the heirs at law to inherit, you need to have a dispositive instrument such as a will or a revocable living trust that says who does inherit from you, who are your beneficiaries, because your heirs at law, in the absence of such a document, are going to be the ones who inherit. And I do want to have you be aware that trusts can be created within a will. Now, a will has no effect until you die. So how can there be a trust? Well, within the terms of the will that you signed, you may have said, I want a trust for my surviving spouse. It can be a tax trust. It could be a supplemental asset protection trust. It could be a grandchildren's trust. Trust can go on for a very long time, or they can go on for a short period of time, depending on what the circumstances are. But when a will creates a trust, whether it's goes on for 100 years or goes on for 10 years, it is going to be what's called an irrevocable trust. Remember, we talked about that earlier? The irrevocable trust is created by your will because you're gone. You can't revoke it now. Nobody can revoke it, and it will play out according to the terms of the trust. So if it's an irrevocable trust, it will have its own tax identification number. It's its own taxable entity. There are going to need to be tax returns, or at least a consideration of, does this trust need to file a tax return? We always recommend that you work with your CPA, your certified professional accountant, to make sure that you get those tax filings correct. So that's what the terms are for a will. Let's talk about the terms for a revocable living trust. So if you are the person that is signing and creating this trust, you are either called a grantor, a settlor, a trustor. They all mean the same thing. What it means is you're the person creating this trust. And likely, if you are creating this trust, you're the one who is putting all your assets into the trust, so you're funding it. And you're likely going to be your own trustee. That means the person who is managing all these assets. And you likely are going to be the beneficiary of the trust, meaning you get the benefit of all the assets you put into the trust that you're managing. So it doesn't feel much different than you're actually owning these trust or these assets outright without a trust. And so this is one of the reasons it becomes confusing, because if you create a revocable living trust, like I just explained, you don't get a new tax ID number. It just uses your Social Security number, and you file your income taxes like you normally would, because you can revoke it at any time. So therefore, it doesn't really change the character of the assets. Now, that's not to say you don't have to retitle your assets into the trust. You do. You have your house, you've got to retitle the house and record it with the county in the name of the trust. You have a bank account, you need to retitle the bank account into the name of the trust. You have a 401k, you can't retitle it into the name of the revocable living trust, but you have to be aware that it sits out there as a non-probate, non-trust held asset so that you get the right beneficiary designation on it. Because these revocable living trusts are just so much like holding it yourself, no surprise, it comes with no creditor protections for you. If you think that I'll put my house into the trust and then if I get sued, my house is protected, wrong. No, it's a revocable trust. It's not irrevocable. Therefore, it does not have creditor protections for you. The big reason that people have revocable living trusts is that it avoids probate upon death. And if there's no good reason for a probate, of course, it makes sense to avoid probate. Keep in mind, though, with a revocable living trust, let's say you're 50 years old and you're going to live to 90, you got 40 years of maintenance on this thing. Means you change residences, you got to make sure it's the new residence is in the name of the trust, bank accounts. You go out and get a new CD because the rate is really good at that bank and you forget to put it into the trust. Well, then you're not managing the trust well. And what happens upon your death is not only is there a trust administration, but there is also a probate. If you have a trust, you know that you signed a will. It's called a pour-over will. And the reason for that is that not uncommonly, people forget to properly fund their trust and maintain it. And so on their death, there has to be a probate to capture that asset that wasn't in the trust and pull it back in and put it into the trust. And that's done through a probate. So not uncommonly with a trust, you set it up to avoid a probate, but you ended up with a probate plus a trust administration, not you. Literally, whomever is your successor trustee. So, key to success and revocable living trust can make a lot of sense, but you have to be aware of your ongoing responsibility to manage it. As I said, the key benefit for a trust is avoiding a probate. Why would you not want to avoid a probate? And with a will, a key piece of a will is there's going to be a probate. Same kind of question, different side of the coin. Why would you want a probate? We'll talk about that to make more sense of it. So I think maybe what might be helpful is let's just take some names of some people and their situations and see what might work best for them. Okay, so we're going to take two couples, Rita and Ted, and Wendy and Walt. And they're very similar in terms of, let's say they have $2 million in assets. Each couple does. That's not a taxable estate in Washington, which right now we're at 2.193 million in the February 2025. Okay. So 2 million non-taxable. What else? Well, let's say that Rita and Ted own their home here in Washington and they own a place in Arizona where they snowbird. Wendy and Walt, they own their own home here in Washington, but when they go down in the winter to Arizona, they rent, so they don't own a home. Both couples are Washington residents, and let's say that it's a second marriage for both, which means that they have kids. So we are talking about blended families. Blended families will always make more complicated an estate plan. By the way, keep that in mind. And one of the reasons for that is, well, not surprisingly, everybody wants to provide for their own kids. So if you want to provide for your own kids, what kind of an estate plan is going to set you up for success so that your kids actually inherit and they are not disinherited after your death? We'll talk about that. Let's talk about long-term care. In this example, let's say neither couple has long-term care insurance. Folks not having long-term care insurance is really, really common. As an elder law attorney, I would definitely recommend that you get long-term care insurance, but I completely understand if you waited too long, your health doesn't allow it, your finances don't allow it. That's one of the things that we do at Elder Law Group here is help people preserve assets, protect assets, and qualify for Medicaid. But that's subject of another day, not today. And let's talk about family history of long-term care for this couple or for these couples. Rita and Ted, yep, they've seen it in their family. Wendy and Walt, yep, they've seen it in their family. Is that surprising? Not at all. After a certain age, after age 65, just very young, 70% of people need some form of long-term care. So, of course, probability speaking, most people have seen some type of long-term care in their family. Now, history of long-term care is different than a diagnosis. A diagnosis, for example, of Alzheimer's makes it much more real. And in our situation, what is going to distinguish Wendy and Walt from Rita and Ted is that Wendy has a diagnosis of Alzheimer's. That is going to make a difference in their planning and what we would recommend for them. What kind of estate plan should they have? Let's start with Rita and Ted. Nobody has a bad diagnosis, and they own property in 2 states. Okay, when you own real property in this state and in Arizona, that says that you're going to need a probate in both states unless you set up your estate plan to avoid the probate. So because of owning property in Arizona in particular, Rita and Ted choose the Revocable Living Trust platform for their estate planning, and they're going to avoid probate in those states because they're going to manage their trust as they should. And when they meet with their attorney, that could be the key factor any attorney seizes upon is, oh, you own property in 2 states? Let's set up a revocable living trust for you. And it does make sense. But let's dive a little bit deeper, okay? They said, well, we had long-term care in our families, but neither one of us have a diagnosis. Okay, still sounds like a revocable living trust is a good idea. And they're pretty capable. They make sure their houses are titled in the trust and their bank accounts are titled in the trust. And so it makes sense that they have a revocable living trust. And they tell their lawyer, you know what? Rita has 2 daughters from a prior marriage. Ted has a son from a prior marriage. We want them to inherit. Could be 1/3, 1/3, 1/3, or it could be Rita's to get the 50%, Ted's son gets the 50%. It's all dependent on what the couple wants, but somehow they want this division such that out of these 3 kids, they're all going to inherit once they're both gone. Okay, that makes sense. How do we do that? We set up within the revocable living trust another trust that is going to be created when the first spouse dies. That's the plan. Let's see what actually happens. What happens is we'll have Ted die first, and the revocable living trust is supposed to be set up such that on Ted's death, his 1/2, and we'll just say they own half of the property is going to go from this revocable living trust, and now there's going to be a new trust created within it. It's called an irrevocable trust, and it's intended to hold all of Ted's property. And the idea with this irrevocable trust is it's still available for Rita during her lifetime, and she can even be the trustee, or maybe Ted's son would be the trustee. But it's supposed to be created. And then once Rita dies, whatever was her part of the trust maybe goes down to her daughters, and whatever's left in Ted's trust maybe goes down to his son. That way nobody is disinherited. That's how it's supposed to work. But Rita is the trustee. Ted has died. She is not thinking about, oh, I should go see a lawyer. And this is one of the key problems with a revocable living trust, is because you are not required to go see your lawyer. You are not required to do a probate. And frankly, you signed it 10, 15 years ago, and you really don't remember what you're supposed to be doing. But you do know, and Rita does know, she does not want to go see the lawyer. Maybe they've retired, or maybe they were difficult to deal with, or more likely, maybe they'll charge money, because lawyers charge money. And Rita has always been very frugal. She doesn't want to pay anybody. So she's not going to go back and see the lawyer, even if they were a great lawyer and they're still available. Rita doesn't go see a lawyer. Now, not uncommonly, Rita and Ted have not shared their revocable living trust with anybody. So the kids don't even know that it exists. All they see is that, Ted has died and there's no probate needed, and they're in the dark. They don't know what's going to happen, but it doesn't seem like anything needs to happen. Rita doesn't set up the trust. What happens next? Well, a lot of things could happen, but what commonly happens is nothing happens, such that when she dies, the trust isn't going to properly distribute as it was intended. Or sometimes, Rita's a surviving spouse and she never created this irrevocable trust on Ted's death. And, maybe she thinks now she's sold this property and she's sold that. All she's got is a bank account now. And, she really trusts her 2 daughters. So she puts her kids on the bank accounts with her. What happens when she dies? How much do you think Ted's son gets? Not uncommonly, he gets nothing. He is disinherited, because even though his parents, his dad and Rita, had good intentions, they fell aside as time went on, and the plan was not implemented as it should have been. There was no lawyer who was involved. Rita wasn't necessarily malicious, but she didn't do what she was supposed to do, and there was nobody there to make sure that she did. So Ted ends up with nothing, or Ted's son ends up with nothing. Rita's kids get whatever there was. So that is an example of an unintentional disinheritance. It is far more common to see that when we're dealing with a revocable living trust for all the reasons I just described. Oh, and by the way, yeah, there could have been legal action. Ted's son could have, gone to a lawyer, maybe he should have, and said, I want to see the trust. I want to make sure this is done right, and this and this and this, which might lead to a lot of angst, a lot of estrangement, legal costs. But that really would have been the only way for Ted's son to protect himself and his inheritance in the example I gave. And, frankly, as an estate planning lawyer, wherever we see that somebody had to sue in order to get something, that's not the result that we like to see, but it does happen. This didn't have to be the outcome. A more ideal outcome was that Rita did get legal counsel and it was set up properly, just like it should have been. And that also can happen, but it really is incumbent upon the surviving spouse to seek out the services of the attorney. Let's talk about Rita as a surviving spouse of this revocable living trust. Is there any asset protection to her from anything, especially if she didn't set up the irrevocable trust? And I can tell you the answer is no. These assets are all subject to taxes, to creditors, and to long-term care costs. So a revocable living trust might sound like a great idea, but dive deeper, ask some questions, find out what can go wrong, and if you have it, how to make sure it doesn't go wrong for you. All right, let's focus on Walt and Wendy. And no surprise, their platform that has been recommended is a will platform, even though that means there's going to be a probate on the death of the first spouse. So why do Walt and Wendy have a will? Because Wendy has Alzheimer's, and they met with their estate planning and elder law attorney. And we know that whenever we're dealing with a very serious diagnosis that is going to lead to long-term care, potentially 10 years or more, we need to protect assets. And a revocable living trust doesn't do that. So a will is what we are going to be taking a look at. And frankly, I don't know if you remember, I said that they didn't have long-term care insurance. Let's say that they did have long-term care insurance. It likely isn't that lifetime long-term care insurance. Those policies are a thing of the past. So maybe they have a 3-year policy, a 5-year policy. Alzheimer's can go on for many more years than that. So having a will, even with long-term care insurance, is a good idea for a couple where we have a diagnosis such as Alzheimer's. So let me explain why having a will is a good idea. Why? Number one, there's going to be a probate. Why is that a good idea? Well, you're going to have a lawyer involved and it's going to make sure that things are done correctly. Okay, that sounds all right, but why? Tell me more. Because Wendy and Walt have a will with the right kind of trust in it. The right kind of trust is a trust that has asset protection for the surviving spouse. In Washington, the only way that one spouse can protect assets for the other spouse once the first spouse has died is if they do so through a will. And if that will has in it a supplemental needs trust. A supplemental needs trust is the type of trust that any government agency, the state, Medicaid, will recognize and honor as one that will protect assets for the survivor. Let me just go through how this would work. So Wendy and Walt live together. Walt takes care of Wendy, who has Alzheimer's. Walt's health fails. Walt dies. The couple has $2 million in assets. Walt's will contains a supplemental needs trust for Wendy. When he dies, there will be a probate. There will be an executor, executrix, a personal representative, whomever Walt named, probably one of his kids, for example, and they will ensure that one half of this couple's estate, remember it's a $2 million estate, so one half or $1 million is going to go into a trust for Wendy. That $1 million that is in this trust is not counted by Medicaid. So let's say, for example, the configuration of their assets is when Walt dies, their house is worth $1 million. They had $1 million in liquid investments. Okay. The $1 million in liquid investments is going to go into the trust. The house is going to stay in Wendy's name. Under Medicaid's rules, a house is a non-countable asset. A $1 million house is non-countable to Wendy. Wendy's going to need to move to a care facility. They have found a care facility because she can't live at home anymore. She's got Alzheimer's. Fortunately, before she had Alzheimer's, she and Walt got their right estate plan in place. So Wendy moves to a care facility, a lovely memory care facility that does accept Medicaid immediately or after a year or two private pay, whatever the situation is, she's got good care now. The house is something that she can keep, or there could be a different Medicaid plan. That's a talk for another day. But the $1 million in this trust for her doesn't interfere with Medicaid, even though Medicaid says a single person, which is what a widow is, can only have $2,000 in countable assets. Well, let's say that's all she has. She's got $1 million in trust. That does not count. You can see why this might be a good thing. Medicaid is not required. It doesn't say, trustee, you must get Medicaid for Wendy. But if you can get Medicaid for Wendy, and if it is a good quality of care, then that is what you would do. And therefore, the couple and their children will have preserved all of these assets. A trust has been set up. What is that trust going to say? On Wendy's death, it goes wherever Walt said it goes. And if there's any other assets that are left in Wendy's name, it's going to go where Wendy says it's going to go. So this couple is able to preserve virtually all of their assets for their beneficiaries, and nobody is going to be disinherited. So for reasons like I just explained with Walt and Wendy, that is why a will might be a better idea. Take out the whole Wendy's Alzheimer's and all of that. Wouldn't the children, Ted's son, have been happier had he received something and he didn't have to sue for it? With a will, he's much more likely going to inherit because it's going to be done correctly once the first spouse dies. So this is the reason that a will might be a better option. Now, I'm hearing you say, yes, but that means probate. Absolutely it does. So under Walt and Wendy's situation, we have an assurance of $1 million of asset protection, and that the plan is going to be carried out just like Walt and Wendy wanted, because it is a will that has a probate requirement. Through probate, and very few people do probate on their own, typically lawyers are involved. Is it going to cost money? Absolutely. Just like the estate plan costs money. Just like the probate's going to cost money. Let's say that they've got $10,000 to $20,000 wrapped up with all the legal work, all of that for the estate plan and for the probate and whatever else. Let's say that they've got that much money wrapped up. Is it worth paying $10,000 to $20,000 for $1 million of asset protection plus Medicaid eligibility? That is a question that you should talk with your attorney about and get a good, clear answer. Because sometimes people are penny wise and pound foolish, and they will have a horrible plan or a do-it-yourself plan, all because they don't want to invest in themselves, in a good plan for themselves to protect them, their money, their spouse, and their kids. And that short-sightedness will result in spending very little money on an upfront estate plan, perhaps a lot more money on a post-death administration, especially when there's lawsuits and litigation because it was a bad plan. But the point of it is what is the benefit? If there's a benefit to the probate, and if it makes sense for your situation to have a probate, then don't shy away from it. There's a reason that probates are often recommended by elder law attorneys, much more so than traditional estate planning lawyers who don't understand Medicaid's rules and how Medicaid's rules work and why a will might be a really good idea. That is pretty much my wrap up for basics of wills versus trusts. I hope there's some good information you can take away for yourself or to share with other folks or loved ones, family members. If you have any more questions, feel free to reach out to us at ELG Estate Planning. Our website is elgwa.com. We also have our YouTube channel with lots of information, or you can call us the old-fashioned way, 509-468-0551. Thanks so much for watching. Again, I appreciate you being here with us today. Take care now. Bye-bye.